I'd like to welcome everyone. My name is Leah Wing, and I'm co-director of the National Center for Technology and Dispute Resolution. And you're about to hear from the director and the man who gave birth to the idea of online dispute resolution, Ethan Katsh. He's on the panel to come. And I just want to take a moment to welcome you to the entire series. And then I'll hand it over to Orna and Ethan, who are going to chair today's panel. So I'll begin by just highlighting who's on the panel. You can see we have a distinguished set of presenters. They're going to be doing introductions of themselves shortly. This is one of 7 webinar series we're having this autumn to celebrate the brand new online dispute resolution theory and practice treaties. And it's wonderful to be able to have all 35 authors and the 3 editors be able to join us for this series. If you're interested in buying the book, then here's information. I will also be putting it in the chat as we go through. You can see that there's a 40% discount. So hopefully this can be added to your shelves for your reference and for those of you who teach. As I mentioned, there's 7 in this series. We're on number 2, and the next 5 are taking place during Cyber Week. If you're interested in learning more about the entire program for Cyber Week, it's a free international online conference for the entire first week of November with a wonderful set of activities, and there will be a presentation every day related to the book. You can go to odr.info and there'll be more information there coming out in the next week or so. So with that, I'm happy to turn it over to Orna and Ethan. Thank you.
Hi, everyone. I'm absolutely delighted to open the second webinar in our series celebrating the publication of the book Online Dispute Resolution Theory and Practice. A bit blurred. Oh, was the back, so I hope you can still see it. Today we have 5 authors who will present 4 chapters. We're actually in 5 time zones. Very exciting. We all sort of fall under the broad topic of artificial intelligence and online dispute resolution. Each speaker will present him or herself and deliver a brief presentation of their chapter in the following order. Ethan Katsh and myself will open and will speak about AI and the future of dispute resolution. Then Brandon Malone will speak about smart contracts and blockchain. Chris Draper will speak about ODR and data security. And last but not least, Kathleen Paisley will speak about the application of the GDPR and cybersecurity requirements to digital dispute resolution. After the presentations, we will follow up with each of the other speakers with some questions that will tie their chapter to the webinar topic. And then we'll open it to for Q&A with all of you folks. We have 75 minutes in total, so we want to start. And it is with great pleasure that I present my dear friend and longtime co-author and collaborator, Professor Ethan Katsh, the father of ODR. I think he's also been called the grandfather of ODR, a true pioneer and the co-director of the National Center of Technology and Dispute Resolution, which is hosting us today. And I'm Orna Rabinovich-Einy from the Haifa Law Faculty, where I teach and write on ODR, ADR, and civil procedure. So Ethan will start us off with our chapter that is entitled Artificial Intelligence and the Future of Dispute Resolution, the Age of AI-DR. I will share the slides and I'll let Ethan start and speak later.
Okay. Almost okay.
Yeah.
All right. Thanks very much, Orna. I'm not going to say anything more about myself. Too much flattery is disturbing, but I don't know if I can show this. This is the book that Orna and I wrote together, and it's called Digital Justice, and it's been out a while, but still, I think, meaningful. So if any of you are interested, this is an Oxford University Press book. 4 questions that we're going to deal with, Orna and myself. Orna will deal with the last one, challenges for AI. I'm going to take the first 3. And the questions are, the first question is really the hardest. What is AI? It's not all that difficult to describe what AI can do or whether we need it, but it is somewhat difficult to identify the kind of intelligence or the meaning of intelligence in this context. So let me just try briefly. And the idea of the fourth party was put in here, I think, to possibly help clarify what AI is and its origins. The fourth party idea, traceable back to something Janet Rifkin and I wrote a long time ago, originally was used in the sense of tools helping the third party. The assumption was that this technology could be helpful because third parties, the role of third parties and the activities of third parties revolve around the use and processing of information. So that concept, looking at the use and processing of information, originated in one context, but we're trying to bring it over to this new context of artificial intelligence. Again, artificial intelligence in the sense of using data and algorithms to change and learn from experience. I would say the key element here is the ability of the software to learn from experience and then take action based on that experience. So relying on algorithms, a difficult word to digest sometimes, but meaning really sets of instructions and calculations and following rules to solve a problem and complete a task. And the reason AI is being used so much is that AI, but not humans, can identify and respond to patterns, trends, and it can do it at a large scale where humans can only do it at a small scale. So on your next slide, what can AI do with data? Well, this gets a little more detailed and precise, but you can see that all of these are revolving around the processing and use and communication of information. So that's what I would like to highlight or stress from this presentation, that we're talking about things that mediators and arbitrators do, but they don't do it at the scale or at the speed that AI does it. So AI, I'm not going to read all of these, but really it was an interesting list to generate, and it shows how how often and in many areas we make choices and we make recommendations, and all of this derives from the use of data. So these are not necessarily positives. You can go to the next one, Orna, if you like. But the use of data and the collection of data and the processing of data can certainly be problematic. Three things to keep in mind, really two things, because the middle one is a little easier to explain, but our interest in this, I think, derives from the fact that the whole disputing environment is changing because AI is generating so many disputes, not only AI, but technology in general. New technologies generate new relationships, new kinds of transactions, and those relationships and transactions don't always go smoothly. But if millions of transactions are taking place, inevitably, there are going to be disputes. The idea that AI can resolve disputes really stems from the same source, and that is that resolving disputes involves processing information, collecting information, using information, identifying information, all those things, all those elements that were on the previous slide. But AI can handle large-scale disputes quickly, and that's its attraction. Lastly, AI can prevent disputes if you can identify what the problems are, and the problems are information or data related. Then you can try to prevent these disputes. And I think in our daily lives, we see attempts to prevent disputes. We see attempts to resolve disputes, and we see it more than we'd like, AI generating disputes. I don't know how much time I've used, Orna, but I think we might move on to yours.
Sure. So I think to continue what Ethan has said, basically AI is not, it's important to say that while most of our writing has been on ODR and there is a clear connection between AI and ODR, they're not synonymous. And AI is also employed in the face-to-face dispute resolution arena. And the use of AI, as Ethan said beforehand, was meant to enhance the way we address disputes as well as explore new arenas. Perhaps we'll see that in the coming years of dispute prevention. And when we look at our sort of pre-AI dispute resolution landscape, I think we can say it suffers from two main deficits, two main problems. One is sort of on the efficiency access realm, and the other is on the fairness or perceived fairness milieu. And while clearly AI has tremendous potential for enhancing the efficiency of dispute resolution processes, the initial hopes that it would also address some of the fairness issues, the inaccuracies, the inconsistencies, perhaps even the implicit bias that is associated with human third-party dispute resolution has given way to some disillusionment. The very technology that was expected to decrease some of those phenomena has actually introduced bias of its own. The hopes of enhancing access to justice by reducing costs, complexity, making proceedings shorter, enhancing capacity through AI, assisting pro se litigation by facilitating the journey such participants take in their attempts to resolve their problems. All of these hopes are also met with a reality in which AI can actually make repeat players and strong parties even stronger by providing them more data, more tools or novel tools, and enhancing their existing capacity, making the playing field even less leveled, perhaps. AI needs data, needs a lot of data to perform its functions. Without data, it is ineffective. But once we introduce data, we also introduce bad data. We introduce problematic use of data. We can intrude on privacy. We could also, bad data could also result in mistakes or even in biases. AI has been critiqued over and over for its black box nature. While we certainly see the outcomes that AI produces, we have very little understanding of the processes under which it operates, the ways it creates the correlations it finds, and even those who are responsible for AI, the programmers, often do not know themselves or cannot explain themselves how the software, the algorithms operated. While initially perhaps there were naive expectations of technology being neutral, we now know that technology is not neutral, but is a reflection of the values and the biases that the humans who design it bring with them to the technology. And finally, I think one of perhaps a different type of concern that is also quite significant is that AI is not human. We know that, and that's why that's where its attraction lies in many respects. But it's also a source of discontent because many times human attention in dispute resolution is associated with creativity, with the ability to tailor individualized solutions, to see the particular nature of a specific dispute and not operate on mass scale and not look for correlations, but actually see the individual and understand the unique nature of their case. And obviously, that is not something that AI can deliver for us. So in a previous article, which we actually re-edited for this volume as well, and is not being presented this evening, well, maybe I'm sort of presenting it now, Ethan and I described the impact of technology in terms of boundary blurring. So while AI is not the sole source of this phenomenon occurring, it certainly contributes to the boundary blurring and to other realms, but also to the main realm in which it operates, the distinction between human and machine. So we can see that while we like to think that decision support, the realm in which we see AI operating today, is quite distinct from decision making. As we reflect on it further, we see how this line separating supporting the decision, predicting the decision, actually making the decision can be easily eroded. Similarly, as Ethan discussed, the line between dispute resolution and dispute prevention is also a thin line as we use the data that is produced in the dispute resolution process to actually think about discerning patterns and correlations and how to prevent the disputes from arising at all. The line between online and offline that is already or has already been eroded with the rise of ODR and its adoption in courts and other realms is further being eroded as AI is being introduced here and there, and it is becoming very difficult to think of dispute resolution that does not involve some kind of technology. And there are many discussions about the definition of ODR, and I think the introduction of AI sort of gives us another push here as well. And the line separating formal and informal dispute resolution is also one where AI is contributing to its further erosion, as well as the professional realm, where AI is beginning to displace some of the professional activities that we have long associated with lawyers, but it is also contributing to the erosion of the realm that was traditionally associated with lawyers by introducing new types of professions into the design of dispute resolution systems. So, in conclusion, if you read our chapter, in which there is a lot of other information we couldn't talk about today, you will see that we say that use of AI in dispute resolution, both online and offline, is still in its infancy, but we see great potential for its growth, and we anticipate that its use will grow substantially in the realm of both decision-making, actual decision-making, as well as dispute prevention, as the boundaries, these boundaries and other boundaries continue to blur. So thank you very much, and I'll pass on the baton to our next speaker as I stop sharing.
Hello, good evening. Yes, I'm next. Am I on? Thanks. I think, yes, hello everyone. My name is Brandon Malone. I am a barrister with Quadrant Chambers in London and also an arbitrator with Arbitra International. I chair the board of the Scottish Arbitration Centre and will therefore be your host for ICA 2022, as we keep renaming it. It was originally meant to be ICA 2020, but there you go. I'm a member of the ICC Commission and I chair the New York City Bar ICA CPR Working Group on Cybersecurity. and international arbitration. And I'm going to talk about smart contracts and blockchain. So smart contracts have the potential to radically reduce the scope for disputes in certain types of contracts, and in some cases they may eliminate the possibility of a dispute. Blockchain enhances the functionality of smart contracts, and blockchain also has the potential to enhance the arbitration process or the dispute resolution process, and in some cases replace formal dispute resolution. Smart contracts are not especially new in the sense that a vending machine as a form of smart contract, technology and blockchain technology in particular has increased the options for the automatic execution of contracts. A smart contract is an agreement which is recorded in whole or in part as computer code, which is capable of automatic execution of some or all of its terms. But to understand smart contracts, it helps to have a basic understanding of blockchain technology. I'm sure everyone here is familiar with the basics of that, but many lawyers aren't, and I'll just go into it a little bit. So in simple terms, blockchain is the solution to the double spend problem. If you have it arose out of Bitcoin, really, the Bitcoin implementation, i.e. digital money. The problem is if you've got a banknote, for example, you spend it, you hand it over, you don't have it anymore. You may have made a photocopy of it or some sort of copy of it, but it's unlikely to be very convincing unless you've been able to do holographs and transparencies and plasticizing it and everything they do these days. By contrast, a digital token, digital money, it's extremely easy to make a copy of that. We can all do that. You just press save as, and that's in the nature of any digital record. You can make an exact copy of it. Obviously, there can be safeguards against that, but by and large, anybody reasonably competent is going to be able to make a copy. So that's the problem. What's to stop you spending that digital coin over and over again? And the blockchain is the solution to that. So you have these transactions recorded on a distributed ledger on an add-only basis, which means that if you spend this token once, the system knows it's been spent. And if you attempt to spend it again, the system is going to reject that because all of the computers on this distributed ledger know that that token has been spent by you and it's not yours anymore. And that new piece of information that you've spent the token or part of it or whatever is added to the blockchain and cannot then be altered without consensus of the whole network, which you're not going to get. So you don't have to use blockchain for a smart contract, far less a cryptocurrency. But what blockchain allows is the incorruptibility of information and also in some circumstances for automatic execution. So if you look at some of the use cases of smart contracts, a good place to start is what they call parametric insurance. Parametric mainly simply referring to parameters. So you have a set of conditions within certain parameters, and if those conditions are met, the insurance policy will respond. And a good example of that is crop protection insurance. Oranges, for example. And I, despite my accent, grew up in Citrus County, Florida. So this is a particular area of experience for me. But if an orange is damaged by frost, you can't sell it as an orange anymore. You have to sell it as juice. And it's less valuable than it would be if you could sell it as whole fruit. So the citrus farmers insure against frost. Now, if you think of an automated insurance contract for that, it says that if the temperature falls below 0 degrees Celsius, the insurance policy will pay out a sum in agreed damages or loss, which is meant to represent the difference between the whole fruit being sold and fruit which is damaged as frost and can only be used as juice. Now, in a traditional contract, if there's frost damage, the farmer would call the insurance company and make a claim. The insurance company would send out a loss adjuster to adjust the claim. They would then make an offer to settle the claim. The farmer might like it or might not like it. If they don't like it, you might end up in formal dispute resolution, litigation, arbitration, what have you. If you contrast that with a smart contract, the farmer pays the premium based on risk and the assessed level of loss, pre-assessed level of loss. And then the smart contract is linked to an independent source of information about the weather, a data stream, an oracle, as we'll come on to describe. And if that temperature drops below 0 degrees during the insurance period, then the smart contract reacts and payment is made automatically. No claim, no loss adjusters, no lawyers, no litigation, no arbitration, no scope for a dispute. If then, as we're very much accustomed to with computer contracts. So these smart contracts operate just like a computer program. If a certain event happens, if then something else happens. And the illustration here, if the temperature drops below 0, then the policy pays out. And the more that the drafters or coders of the contract are able to anticipate the eventualities of a contractual situation, the potential disputes that might arise in a contract, and then cater for them with an if-then program set of consequences through the contract, then fewer actual disputes are likely to arise. But there are some obstacles to the widespread adoption of these contracts, and you only have to think about it for a moment. There are difficulties in getting a smart contract to interface with the physical world. It's difficult to think of all the eventualities that might arise in a contract, and it's difficult in converting some legal concepts into code. And just touch on those. So if you think about the interface, smart contracts use what they call an oracle. An oracle is a source of external data, which the smart contract then uses to trigger the execution when predefined conditions are met. There are various types of oracles. We'll not get into all of them just now, but an updating database like those used for temperature, for example, for crop insurance, or for takeoff and landing times of airplanes, for example, in flight delay insurance. These are examples of oracles. But you can't currently use an oracle, for example, to determine who was the person liable in a car accident. That's still going to be a litigious issue with accusations of blame and the need for human inquiry and potentially formal dispute resolution. Another problem, as I say, is trying to cater for all the eventualities that might arise in a contract. Crop insurance, very easy. Is the temperature above or below 0? If it's below, it pays out. If it's not, it doesn't. But in a more complex contract, it's much more difficult to anticipate every eventuality. If you think of even a simple building contract, for example, is it possible to plan out and provide for everything that can happen in a building contract in computer code and to link every eventuality to an external oracle that will then allow the contract to determine the issue automatically? No, it's not, or at least it's not at the moment. And then there are difficulties in coding subjective tests. So contractual conditions are not, some contractual conditions are not amenable to oracles. So for example, if you have a condition that is satisfied if one party exercises reasonable endeavors, is an oracle going to tell you whether or not that's happened? Not at present. What about good faith? Again, pretty subjective. And we don't really have the capability to have computers in code that can respond to that sort of contractual condition. So that's a very quick canter through the concept of smart contracts and how they tie into blockchain. They are certainly getting currency with new use cases of smart contracts evolving, but we're not yet at the stage where they're going to replace traditional contracts and lawyers and dispute resolution. And I think on the contrary, what we're doing is emerging into a time when we're going to need very specialist lawyers who are conversant both in legal code, but also computer code. So we needn't panic yet, but who knows what the future holds in store. Thank you.
Thank you very much. Chris, please.
Hey, thank you. And I'll be sharing screen with some images here. And the focus of my talk is going to be really AI within the confines of how we're looking at within Chapter 7. So Chapter 7 is on ODR Data Security. As a quick sort of disclaimer of bias, I'm what would be called a technologist, so to speak, by origin. So I look at these slightly differently. So I've come into this world slightly differently. And I think one of the things that we need to, be fully sort of open to is the idea that AI is fundamentally an ignorant kid. I mean, what we mean by that is it's going to think things should be going a certain way. And a lot of our role when we're looking at ODR from a data security perspective is to really sort of, not get bullied by it, okay? Because as we're looking at our emails, for example, this was one I had today. It's right. It wants to make sure that I say thank you and nothing more, and then put my name in. It's going to have a certain way that it believes that we should be responding based on what it's seen. And what's very important is a lot of these words have important meanings, that if we get these meanings wrong, as I think we've all seen these text ones with autocorrect, all of these little pieces are AI elements that are starting to embed into our systems. So it's very, very important as we look from a data security perspective, as we start to look at our ODR systems and assess their quality, assess where the risks are, and assess what AI does on impacting them, we need to really sort of step back and think, how does this happen and why does it happen? Fundamentally, as Ethan and Orna head on a little bit at the beginning, AI fundamentally is a sort of black box, as Brandon identified as well. We've got these processes that take in a whole bunch of data inputs, and from those, what our assumption is, are going to get us the best outcome possible, right? So whether or not we think this is the best outcome or whatnot, the answer is, with the limited data it has when it looks at a data set, because keep in mind, while it has the ability to look at large swaths of data, like any process, it's going to make assumptions based on what it sees. And based on what it sees, it could see the exact same thing differently, and we could get two very, very different outcomes as a function of what it sees. These are things that are of concern to us when we talk about bias. We talk about, bias as we see in the system, and in some cases is just, man, we just haven't seen enough stuff. At the same time, some things are just hard to assess. This is, I think, one of Brandon's main points is, even if we are the human, some of these things are hard to evaluate what that image really actually even meant. What was the emotion in that image there where our AI could have gotten to two answers? And it's important to think about, while we think about the AI as a black box, there is an honesty in AI that is actually incredibly valuable, that at least we know all the inputs in some cases. Whereas if we look at judges, which are also a black box, they have these subconscious influences, data streams, and external processes that are influencing their data inputs, even if their data inputs are lesser, to the point where we have to be clear that this elegant ignorance that is AI can never be separated from the human that influenced it, whether that influence is constant or whether that influence ended at design. The human black box is fundamentally the same, with a lot more pieces we don't understand. So again, this elegant ignorance is positive. There's an honesty in it, but we need to understand how this ignorance manifests itself if we're going to actually use it in our systems smartly. Now, when I'm talking about systems in both Chapter 7 and today, and where those influences of AI are, I'm looking at an ODR system as most of us would likely use it. What we mean by that is our ODR system are all those tools, whether they be old physical ones or they be new digital ones, that come together to help us support the process of dispute resolution. ODR is not defined by its I would argue, sorry, I know that there is debate on this, but I would strongly argue that ODR is not defined by the technology used. It is defined by the process of dispute resolution which we're attempting to solve, and technology is inserted as a support, but it takes in all these other pieces too. Just because you're doing ODR does not mean you won't take physical notes. Just because you do ODR does not mean you won't have physical storage. Just because you have ODR doesn't mean we won't sit on a telephone, right? Telephones, well, I guess telephones technically are online in a lot of cases now. The point is, it's this entire system we need to be looking at. When we start to consider AI, and we can start to consider, as I first said, our first role is don't be bullied by AI, is our number one role as neutrals, or individuals who are choosing the technologies that are going to be defining what is the fourth parties associated in our system. And I say parties because our role is to ensure that we do not implement these technologies in a way where we risk access to privacy or confidentiality violations. We need to make sure that the way we think about AI and think about its assumptions of our processes as we embed them into our processes do not allow us to implement them in such a way that we let people who shouldn't be in, or we allow situations where, again, we cannot successfully achieve our outcome if we are not facilitating the sharing of information, yet we need to make sure it's shared to the right place. So we need to make sure that our AI, as we're looking at it from a security perspective, is not providing access to these risks. And as we do that, we need to look at each of our processes as we go through, right? For example, in this one, if I'm talking about I've just done a session of mediation or something, I've taken my physical notes, I've moved into the word drafting process. There's the system of identifying, oh, this file should be named this. That's an AI-based tool when you look at AI fundamentally, right? Document storage, when I actually go and store that, there's plenty of little new add-ons you can do that say, oh, hey, you've stored this, you've shared this here, and by the way, these other people, these might be people you'd want to share with too. Every time I sit there and identify, okay, I'm going to share this file with this individual, I'm going to type their email in, as it autofills that, that's just like it telling me, you should say thank you and nothing else. Or you should use this word in this situation as you're drafting this agreement, and this word is not the right one for you. When it starts to suggest these items, that's an AI function. As it starts to suggest, hey, by the way, you didn't attach a file to this email when you said attach. Really, really, really helpful. Until it starts to suggest other things that I don't want. Our question is, as we look at these simple processes through our systems that have a mixture of technologies, how should we think about these? As we look at a different example, my real-time communication tools, Zoom in itself does not define ODR. I'm not doing ODR because I use Zoom. I use Zoom for the classroom. I use, or any other video conferencing real-time communication technologies. Just because I'm using the technology doesn't mean I'm doing ODR. And when I'm using that system, it's going to have different risks associated with them. And I have to be thinking about how I'm plugging them into my system. If I have my, do I have a situation where I'm auto recording, or does it say, oh man, you've always recorded, so maybe we should record this one for you. Maybe that one really shouldn't be recorded. When I actually upload, when the notes are automatically linked, or I say, it'd be really, really cool if all the notes in this session were actually linked into Evernote, and then, oh, it saw a certain word, and so it's going to create a task for me, and that task for me is going to start a document generating. All of those things are our responsibility to understand so we can harness their benefits while mitigating their risks. AI is not necessarily, again, good or bad. AI is just a thing. It's an item, and again, it's embedded in so many things that we're doing when we look at, as we frame Chapter 7, as we frame the discussion here of how we think about it within an ODR system. It's something we really, really need to take a step back and see, what are we doing? What were we intending to do? And does this tool understand our intention well enough to actually do it for us? Because in a lot of cases, as we're getting going, especially for those who are starting to use technology, for the first time, but most importantly, with people who have become incredibly familiar with what they think the technology does, it becomes very dangerous if we are not stepping back and being thoughtful about these. It is our responsibility, because of the embedded nature of the human into these tools, to be the one, as Brandon pointed out, it's our responsibility to see around the corner, because this tool can only process what it sees. The elegant honesty is it can only process what it sees. We have to be able to identify where it's going because we set its parameters. And in that, as we sit back and say, okay, what do we need to see? We need to start looking at where are these benefits and risks. In the book, in the chapter, we talk a little bit more about how you actually run through this process, but not everything we do and not every process we engage in is all as significant if something gets wrong. Within the book, we look at, we discuss, what a data breach is with respect to ODR. Fundamentally, how we look at it is we're saying, okay, anytime that I'm getting data to the wrong place or that data is compromised or lost, I have data that's lost into an untrusted environment, I have a breach. 9 out of 10 times, that's the human that did it. And the question is, where's that access to breach, and what things are most important? And so as we're looking at the risks of AI and the opportunities of AI, we have to weigh them up as to where will these risks emerge. For example, the probability of multiple people seeing an event on a calendar is probably pretty high. But what is the true loss if someone knows that a meeting has been scheduled? In some cases, it can be huge. A initial consultation for a divorce. If I send an encrypted email, or I'm sorry, if an attorney sends an encrypted email intended for my partner, and it happens that attorney is a divorce attorney in a state like Iowa, I have now been released the value of a dispute I did not know I was in. That's a major problem. But that's not how all of these different systems are, right? If I share a certain file, that could be a high consequence event, and depending on how I implement my linkages within these tools, that probability could be a lot higher than I would normally think about it on paper. Or most often, when we look at data breaches and mediations, it isn't because the file system or some complex system screwed up. Someone took the paper from the table and gave it to other people and photocopied it, right? Just because we're digital doesn't mean the risk is higher or lower. And just because it's AI doesn't mean that it's good or bad. What we need to be looking at and what we focus on within Chapter 7 is, how should we start processing what we have in front of us? How should we compare it against what is possible? And how do we make sure that we don't make perfect the enemy of good? These are the most important pieces we need to be considering and looking at as we're thinking about ODR data security, especially in the context of AI. Because again, at the end of the day, no matter how you protect against it, as we said, not to be a broken record, whether or not the human's in the loop, on loop, out of the loop, whether or not they can actually put an influence on that system as it's going, they will always be embedded in it, whether their last touch was on the last action it took, or whether their touch ended at the design of it. The only thing any technology does is it accelerates and amplifies our human actions. And if we be conscious of that and remember that AI is not without its limitations, those limitations fundamentally roll back to something that is human, but they are fundamentally going to allow us, our limitations and opportunities, to be amplified and accelerated beyond what we can do alone. That can give us a context of how we actually need to be addressing, seeing around the corner, and ensuring that we are not losing access to data security in our responsibilities of confidentiality and privacy in a new digitally enabled dispute resolution environment, not one that should be technology driven.
Thank you, Chris.
Oh, sorry.
Yeah, so Kathleen is next. Thanks so much.
No, I was just going to say, Chris, that's a great segue into what I'd like to talk a little bit about today, which is the implications of data privacy, or as we say in Europe, I should say we because I'm actually American. My name is Kathleen Paisley. I'm an international arbitrator. I'm based between Europe and the United States. I have been in my entire career. So if I seem a little schizophrenic, that's intentional. And I'm delighted to be here. I've spent a lot of time thinking and writing and task forcing about cybersecurity that Chris talked about and about data privacy, which now I'm going to talk a little bit about. So in Europe, we call data privacy data protection. It confuses people. When you say data protection, they think you mean cybersecurity because protection. But in fact, data protection rules, as we use as that term refers to in Europe, is essentially privacy. If you are American and you know the HIPAA rules, essentially, one can say that the HIPAA rules apply to all data in Europe. That's a simple way to put it, and it's not accurate, but to give you an idea of the magnitude of your responsibility when you process an individual's data in Europe, also in Canada, also in Brazil, also in California. There's a very heavy duty to all of us who process the data of others to do so in compliance with these laws. They're of mandatory application. You can't waive them. It's like the antitrust laws. You don't waive them. They apply to anyone who comes within their jurisdiction. So in the context, and I think what I'd like to do, because I hope we have time at the end, because I'd love to hear when Chris says it's not the technology that drives ODR, it's what you're doing with it. I'd love to talk about what the definition of ODR really is, because that's something that I grappled a lot with in writing my chapter, because to me, really, I focused on digitally enabled dispute resolution, which essentially is everything we do today. We only do digitally enabled dispute resolution. The days of doing things on paper are gone. So all of it is digitally enabled. All of that means is that we're processing often vast amounts of data across borders, whether even if it's a small ODR case or it's a major investor state case, there's often vast amounts of data being processed, and they're all subject to these laws. So what does that mean? The data, so for example, under the GDPR and most of the data protection laws of the United States are, except the United States and China, and Russia, are based on the old data protection directive. So really the rules that were imposed by Europe in the 90s have been adopted most places in the world except those 3 countries. So if there's similarities with respect to these concepts, that's purposeful. The European Union exported their data protection laws, like Florida exports their fruit, and it was purposeful. They said in their treaties, if you don't apply our data protection laws, you're not going to get treaty coverage. So it was really a purposeful attempt to protect individuals' data. They were drafted before there was an internet, of course, not before there was one, but before it was used widely. So they don't really reflect originally the realities of the internet and the way we process data today. And many of us thought when they did the revisions to the rules and adopted the data protection regulation more recently, they would ease up and realize that the application of these rules in their strict form in an internet-enabled world was not viable. They did the opposite. They doubled down. They said somebody's going to have to protect individuals in this new paradigm, and that's going to be us. And we're going to make sure that it's not only in Europe, but it's anywhere that we can touch. And so essentially when we do arbitrations and there's any data or an ODR proceeding, any data, another ODR proceeding, ADR proceeding, any of those, and there's any data that is relating to an individual in Europe, or if you're governed by the rules, you have to process this data in a way that is compliant. And those are rather strict requirements. Cybersecurity becomes mandatory. Data breach notifications, 72 hours mandatory. And it's not like people say, oh, but I'm not processing people's personal data. I don't have any social security numbers. It doesn't matter. If you're processing my name or the fact that there's a relatively short older woman in Brussels doing arbitration, she's American, that's probably my personal data because there are not that many of us in Brussels. So if you can identify the person from the data, it's my personal data, and that gives me rights and that gives you obligations. And what does that mean for artificial intelligence, for AI? It means that much of the data that we would like to use for AI, we cannot, and we won't be able to, because that data will contain personal data. And people are going to say, you can't have that arbitration award to put into your AI system to try and do predictive coding. Why? Because that arbitration award contains personal data. So the rules apply in many ways, but they apply to the process. So they have constraints on the way all of us should be doing any ODR process. In Europe, absolutely, the ODR directives and regulations say you must comply with the data protection rules, and if you don't, then you're in violation. That isn't as explicit in the case of other proceedings, but with ODR, it's black and white. So when we do all this, we don't really think about it. We think about, okay, what's our platform? What's our rules? What's our, smart contract? But we don't always think about what are the limitations imposed by the privacy rules. And that's what the chapter of the book is about. And those rules are rather significant, and they apply from the time the case is brought until the data is carefully disposed of at the end. And they typically apply to everything because everything allows an individual to be identified. And it doesn't matter whether the documents were created in the context of a business or personal, it's all covered. And processing is everything. If I read a document on screen from the United States, I have processed that information under the GDPR. So it's all, so it just, and it's not necessarily a bad thing because actually, you know, somebody has to keep the rights of individuals in mind, but it does create a constraint that we need to think about. And I don't think we're always doing that. So that's the purpose of, you know, trying to do a little, I think technology is fantastic. I've spent my whole life working with technology and promoting technology. What does the GDPR say? It says, you know, do so in a responsible way. Sometimes a little crazy, but in general, I think the idea is, you know, we should do it in a circumspect way that protects the rights of the individual. So I would encourage you to read the chapter.
Thank you so much. Thank you all for really illuminating presentations. I'd like to now pose a question to each of the panel members, and I encourage our audience to write up some questions in the chat, which I will pick up after we answer. We'll need to answer these questions quickly. Our time is running up, but let's see how much we can get in. So let me go in reverse order. I'll start with Kathleen. So assuming we can use the arbitration data for prediction purposes, how do you see that impacting the playing field? Do you see that as potentially leveling the playing field or making it more extreme in favor of strong repeat players?
It's a great question. I think it can go either way because the data, particularly from international arbitration, so I'm putting aside, you know, a smaller ODR context, but with the major international arbitration data, it's not equally accessible. You can only use AI if you have the data. That's why AI works pretty well for courts where you have published decisions. You can use the predictive technology to take the public decisions and predict outcomes. In the context of arbitration decisions, which are inherently confidential, you have to have access to the awards. Many awards are available because they were enforced and those are accessible to all. But again, you have to have the money and the wherewithal to collect them. So people are busy doing that now. They're busy going all over the world collecting arbitral awards. They're inputting them. Institutions are thinking about how they can use their vast amounts of arbitral awards to do predictive coding. All of them are thinking about it. To what extent can we use this data to the benefit of the parties in terms of predicting? But what is the big constraint? The constraint is data protection. So if those awards identify individuals and you couldn't say that the use of those awards for AI was an inherent part of the process, then arguably you can't use them for that purpose. So you can have big law firms that have access to all this data, but are they allowed to use it? Maybe, maybe not. But certainly, I think unless we figure out a way to create, the technology will become accessible. The technology will become payable. The question is, who will have the data? And will there be equal access to the data? And if there's not, then it's going to create a vastly greater disparity. If there is, then it could have the opposite impact. Because if everybody has an ability to predict, because I'm all about the settlement. And what does the predictive coding really do? It tells me what my range is to settle. So that's why I want to have it. But if I don't have, you know, if one side has it and the other doesn't. So I think it could go either way, and it really will, in my view, in arbitration, depend on the access to the data.
Very interesting. Chris, when can someone be considered technologically proficient in an AI-driven world?
So sort of,
Read his chapter.
That's it.
Well, actually, we do put a disclaimer on the top that I would not consider us to be fully proficient once you finish the chapter, because I do think that the one of the points I made in here that I think is important that we are honest with ourselves about is that just because you have access to and continual presence with the technology does not mean you actually fundamentally understand it. As a quick example, I was at a entrepreneurial class a number of years ago, and I asked them, why is Facebook free? And they're like, oh, because they're doing something good and it's a platform that people like and this, that, and the other. And I was like, and to me, I was like, you gotta be freaking kidding me. And so I said, well, has anyone actually seen the marketing page and opened up the marketing page? None of them had seen it, right? When I said, okay, here's what this is and here's how I can actually, I can target down to this. You're providing these pieces. It's very similar to someone who actually, many may not even know that a carburetor isn't even in a car anymore, right? But we all drive the car and we're all careful with the car. And so I think that the most important part of technological proficiency isn't our presence with it. It's our thought of how it fits into the process we're trying to implement. And I would say technological proficiency to me, and I think is important to all these things, especially with AI, is not necessarily knowing how to code it. It's knowing where it provides risk and failure points with respect to your responsibilities within the system. You don't have to necessarily know, okay, this thing bounces from this server to this server and this one and does this. You just need to know, you know what, I just need to make sure that with this type of video conferencing tool that I can actually see all the participants who are actually in this room. I need to know that that's a risk. There is a video conferencing system where if you don't have the participant list up, because of its default view, you won't be able to see everyone in the room. We were in a mediation one time and I sat and watched, since it was someone I was supporting, to see how long this other person was going to actually identify it. We had someone who was able to enter the team meeting, sit there for at least 30 minutes, and it wasn't until I actually identified them and said, hey, what do you think about this, before the individual responsible for the security of that room knew someone who wasn't supposed to be there was there. That's like having your mediation in a conference room. You just let some random person walk in the door and sit there for a while and maybe even record it and maybe take some notes and maybe actually have their own phone on showing it, right? That's a risk of the technology that proficiency requires us to demonstrate that we know where those risks exist, not necessarily why they exist and not necessarily why we are going to fix them. But if we know, in this is going to require all of us as we step back and say, what is the process we're actually looking to do, right? If you go into a room, I've often joked about this, so apologies for those who've been offended before, you'll be offended again. If you go into a room of 100 mediators, you're going to have 486 different ways of how you mediate, and it's going to change 5 times every 3 minutes. Well, you cannot apply technology to that process. Technology is more linear, technology is more consistent, technology is an amplification and an acceleration of a process that we implement and that we are putting it on its path for. So the number one step to technological proficiency is knowing what I am doing in my really sort of what, if we want to think of it as the human space. We were on a meeting yesterday where the guy goes, when can we get to implementing this system? I was like, as soon as we know what it wants to do. That's the number one step to technological proficiency, is knowing what you truly want to do and making sure that you understand that the tool that is being used to accelerate or amplify a particular process in your human system is doing what you think it does in a way that you can, even if you don't know why, at least can transparently know the outcome of it or the risks inherent in it. So, sorry for the long answer to actually answer without answering in some ways. But
well, it does raise questions to what degree practitioners, even especially during COVID, were indeed proficient in all the technologies they were employing. And I would think not 100% of them.
I would say a quick answer is sub 10%. I think that when you, and this is, and I apologize for taking over time, but this one is actually a very, very important point, is especially when we look at these things, when you look at the fact that 80% of our communication is nonverbal. And you start looking at things like, my eyeballs are going all over the shop. And if we met in real life, my eyeballs are going everywhere like this, you'd probably be like, what is wrong with this dude? And so if all of a sudden I had someone who's proficient across the table, and I now put them into a video world, if they walked into if they walked into the room and just had a stroke or something and only had 50% of their words, I would be pissed that they showed up. And now we're paying them the same rate with 80% of their communication skills gone. I think we undervalued technological proficiency in those manners, and I think we're still doing in some ways the fact that these are communication processes a disservice to many by not recognizing that, yes, technological proficiency does not mean we can turn the box on. It means that we actually know what it's taking away from the process that we are really skilled to do. So, sorry, I'll stop taking everyone's time on this one.
Thank you. And a question for Brandon. You mentioned that currently smart contracts are restricted in their potential for various reasons. How might the development of AI actually change that, if at all?
Thanks, Orna. I think it's AI and it's also computing power. If we think about some of the restrictions I talked about, so the interface with the physical world, at the moment, so the example I gave, I think, was a car crash. If there's a car crash and you need to resolve that dispute, at the moment, there's expert witnesses trying to work out who braked first and who skidded and who was going too fast and all these things. If you have these oracles that can tell you, well, this car was traveling in this direction and too fast, away it came up and it caused the accident. If you have an insurance policy that operates on that basis, and these insurance policies all work together through artificial intelligence and all the vehicles on the road, which may eventually get legislated for, if indeed we're allowed to drive our own cars ourselves anymore in the future, then you remove a whole category of case from traditional dispute resolution. Similarly, we talked about catering for eventualities. If a contract has many ways in which it could go wrong, at the moment, yes, the difference in temperature, easy to, in a crop policy, easy to legislate for. A building contract, much more difficult. But if you have the computing power that you can apply to anticipating things and then monitoring things, it may be that you can remove the potential for actually having a dispute because it's known what has gone wrong. And similarly with complex legal concepts like good faith and reasonable endeavors and things like that. So if you and what is looming on the horizon, which I don't know enough about, and I try and learn more about it, but I'm a humble lawyer, not a technologist, but is quantum computing. So I know that there are claims that they've achieved quantum supremacy. I know there aren't really practical applications of that yet, but when you look at the difference in power between even our most powerful computers we have at the moment, and what a quantum computer is capable of doing, it's almost impossible to comprehend. So if that kind of computing power can be made practical and then applied to the types of things we're talking about today, and that's not going to happen overnight, it's not going to happen in the short term, but it will creep up on us and that will happen all at once. And I think then we will have the potential to resolve or have disputes resolved automatically without or with far less human intervention. An interesting question then becomes, do we want that? Will we accept that? And I think with lower value contracts, we will, because at the moment, the cost of dispute resolution, the cost of arbitration litigation puts people off and there is justice denied. Whereas if you can automate that process and get given an answer, then many people will accept that. But with the higher value claims and the more complex claims, I expect we will still always want people to have their day in court, as it were, and to put their case to neutral humans that they trust. And then perhaps it will be a case of AI assisting the process rather than determining it. But yes, so I think we could. It's very difficult to comprehend the possible computing power on the horizon, just as in the same way that it was difficult to predict or comprehend what the internet would do. But if just looking at the basics of what is being attempted, it seems to me in 10, 20 years, we could be in such a radically different landscape that we're really in a very different place with dispute resolution.
Still some work for lawyers.
Oh, yeah.
Always. So I see a question and comment by Jean Brett, who wrote some nice things about our panel, as well as asking whether there is empirical research on these issues and whether it gets IRB approval. So I can say I've conducted empirical research on ODR and not on AI. I do plan in the future. I've actually reached out to a French platform that uses AI, so I hope that'll happen sometime. But for all projects, for all empirical projects, I do, and I know other researchers who are engaged in this research get IRB approval from their institutions, and we address the issue of privacy. I've worked with court data, so it was public data, but in any event, it was transferred in anonymized form to the extent we can anonymize it. Also, I think Chris wanted to raise an issue.
Yeah, I'm sorry. I think one of the things that Brandon said there, which is I think one that I think we would do a significant disservice not to address, is this issue of low value cases, because I think that is something that is inherent in our acceptance of AI driven systems, is that there is this concept of a low value case. So I'm, for example, I'm on planning and zoning for our local city, and we have this ordinance, and we have, okay, well, we have to, we have to do X unless it's unreasonable. And all of a sudden the question is, okay, where does reasonable end, right? And we had one that came up to us that said, okay, we have to do this, and usually every week it's like, okay, it's 125,000, that's unreasonable. It's $125,000, it's unreasonable. It's 150, it's unreasonable. And then it came through as, well, it's 25, so it's reasonable. $25,000 for a convenience store is 1.5 FTEs. Now, you can argue about the morality of paying someone so little, but the fact is that's 1.5 employees' years of time in this business. That is a low value case to the city. That is a high value case to that person. You're talking 1.5 years of earning potential. And inherent in our discussion of when AI is appropriate is this idea that we have access to filtered outcomes, or that we have access to a right outcome, or that we have access to this idea that accelerated process is justice. I think that and I know there's a lot of discussion about it. Embedded in Jean's comment is like who's doing this. I know we've had many discussions on it, but I think that we will continue to. I think we should be challenging that fundamental assumption of low value as we move this forward, if we're going to be honest to the pursuit of access to justice, because accelerated injustice is just worse. And some of our systems have access to be doing that. And I'm sorry, some of our systems are doing that. It's not that we have an access to it. We're doing it. We're doing it because we're not paying attention to it. You're looking at recidivism tools. Those are accelerating injustice. We're looking at like the debacle that was going on in St. Petersburg, Florida with predictive policing. Those are accelerating injustice because we are being light to the idea of low value. And I'm sorry, Brandon, this isn't an attack. This is a general comment. I agree aggressively that we have been consistent in our assumption, especially in the courts, that if it's low value, don't worry about it. But we have not been honest with understanding where low value exists.
But I would actually like to add that some of what the empirical research has been doing for us is actually also showing new ways of evaluating whether our traditional goals, these are the same goals in our justice systems, are being met, whether access is enhanced, whether perceptions of fairness are being met, and whether substantive fairness or distributive justice is being conducted. So there are, I think, a lot of interesting empirical projects out there, both lab experiments and working with data, that are helping us explore these questions. And I think part of what we'll have to do is also experiment with different types of cases, what be they defined as small scale or less small scale. And I think as it is in dispute resolution, online and offline, the answer is often quite contextual, and we will need to explore and examine and evaluate and receive IRB approval and then publish all of our findings. So I see Marez. Yes, please, Kathleen.
So I just want to make a quick point. You know, as I said, in Europe, the European Union has really embraced ODR for consumer disputes. So as many of you know, there's nobody that is more protective of a consumer than a European. We are extremely protective of our consumers. You cannot pre-agree to arbitration, all those kinds of things that, you know, I actually agree with, but which are possible in many countries are not possible in Europe. Why have they encouraged ODR for consumer disputes? Because without that, you don't get any justice, because it takes 4, 5, 6 years to get a case through most of these courts, and the only and a certain degree of money. So it's like some justice is better than no justice, and of course that is an economic prerogative. But I would just say I think that while I totally agree with you that we should not make an assumption about what a small claim is, I think we also have to be careful in finding the right balance between, you know, some degree of justice, which ODR can offer, and what for many people is no justice at all.
I think there is, I think one of our challenges, though, that we have in this is often believing that justice is a line in the sand, right? And that justice is actually repeatable. So I think that there is a fun, actually on Leah and Ethan were gracious enough to allow me to post a sort of a, you know, that's something that's been floating around for a while on ODR.info about, you know, the justice optimization. Like, should justice be an optimization versus an actual set thing? I don't get to it. Do I ever get to it? Can I actually have a system that is, equal, and can an equal system be just? I think that at the same time that those are important items. So, you know, when we say access to justice, access to what? There are a lot of discussions about, you know, and when we say access, we often think of access to a lawyer. We think of access to a mediator. Well, are they really helping sometimes? You know, do we, you know, are we, number one, defining access correctly? Number two, are we defining where the end game is correctly? And I think that especially this need to be honest with those fundamental assumptions and our fundamental verbiage is vital, because as we start bringing AI in, again, you know, it has an elegant ignorance that will not see and be able to correct that context if we do not define it, because again, it is fundamentally an ignorant kid who is learning, and it is fundamentally going to have to know that context, and we're going to have to be honest about what it is with it, because it can't learn that on the fly in a way that we'll be happy with.
Sorry, just
please, Brandon.
Just, you know, what is we talk about justice. What is the right answer? Is the arbitration tribunal always right? Is the judge always right? Ultimately, they are, because they've got the power. But the point is that the parties have had an opportunity to go to someone neutral and have their case examined. And this is this day in court thing. Now with the ODR, particularly with artificial intelligence, you're expanding the ability for people to get that neutral decision. Is it right? is it wrong? Is it ever right? Is it ever wrong? It's difficult to say unless someone is going to say this is absolutely the right answer, absolutely the law. And sometimes it's black and white, but that's pretty rare. Generally speaking, it's down to the judgment of the tribunal on the day. And I absolutely agree with you that it's not fair to talk in terms of a low value case, but the reality is that justice is very often financially beyond the means of one of the parties, and that this type of procedure has the prospect of expanding a form of justice to those parties otherwise excluded from it. And if we had more time, we could talk about the Kleros project, which is very interesting, crowdsourced wisdom way of resolving disputes, whose mission statement, if you like, is to expand justice to people who are otherwise excluded because of cost.
But Kleros is an actual great example of sort of the neoliberal concept of the crowd is wiser, right? If I have 3,000 car salesmen in a room, that doesn't make them more honest. Unless I pit them against each other, now I theoretically have an efficient market of concept. But I think in some of these, those Kleros jurists, some of these, especially the ones that are looking at these crypto-based spaces, I think there are a few fundamental assumptions in there that with some of our biases, we are going to not see around the corner of the risk that we haven't examined what we truly mean by our desired destination or by what access to it means. Because I agree with you that the best we can do in some cases making sure someone's heard. Is being heard justice?
And yet, Chris, I think part of, we have some limiting thoughts on what can be measured and what can be examined. I think we still think of justice in terms of face-to-face activity. And we have now many new opportunities to actually measure different facets of justice in new ways, which we didn't have in the past, and they could feed back into our concepts and our understandings of what constitutes justice in these different contexts. So this is, again, something I would think of this as an ongoing activity in which we refine our understanding and continue to examine. I saw Kathleen wanted to say something, and then I think we need to wrap up our discussion.
No, I'm fine. I think it's an extremely interesting discussion because I do think, for example, if you look what the Iraqi Claims Commission did, what they said was, we will give a set amount for this type of claim. You are a worker, you came from these 7 countries, you will get X. No one thought that that was fair per claimant, but it was a way of of giving some justice. And I think it's from an economic perspective, you look at it like, to some extent, these smart contracts are like smarter versions of a liquidated damages clause, right? You're saying we're not going to get into the details. If this happens, you get Y. So I think it's very interesting from an economic and a fairness perspective. And these are the exact kind of conversations we should be having a lot more of. Because personally, I could have a long conversation with you, Chris, about Facebook myself, and then you got to get to Google, and then, oh my God, you could just go on and on, because they are really, well, we'll have a conversation offline.
And it sounds like we should all reconvene for the next few webinars and have these conversations there as well, because there are many wonderful other chapters that touch on some of these issues and many more. We've had wonderful comments in the chat, and the discussion has been both oral and written as a good ODR process goes. I see Ethan has a comment as well. You're muted, Ethan. Ethan, you're muted.
No, I would like the last word just to thank you, Orna, for moderating this. And certainly incredible gratitude to Leah for not only organizing this and being responsible for all of this, the webinars. So I hope we'll see you back at those. Lastly, Jean, if you're still here, Orna received an award for the as I recall, she and J.J. Prescott received an award for the paper they published on the Matterhorn cases. So more than an example, a model, I think. Anyway, thank you all
That's
for
very
coming. And this was a pretty intense conversation, finally. So I think it went as well as it could have. Thank you.
Thank you very much. Wonderful, rich presentations. I learned a lot. Thank you. And thank you, Leah, so much.
Thanks, everyone.
Thanks, everybody.
Thank you.
Thank you, Leah. Thank you, Ethan, Orna.
Bye, everyone.
Hi, Fernando.
Thank you, wonderful panel.
Bye.